Hello, everyone. Welcome back to our channel, U.S. Immigration. We hope you're doing great. Well, in today's video, we will be talking about brace for immigration changes to be introduced overnight, warn attorneys, as inviting public comment is no longer required. In a move that's raising eyebrows from Delhi to D.C., the Trump camp has pulled a fast one, reclassifying immigration as a foreign affairs function, effectively bypassing public scrutiny. It's like changing the rules of the game mid-match, and Indian professionals in the U.S. could soon feel the heat, especially those on H-1B and student visas. If you are interested in this, please pay attention and watch the video through to the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So, without any further delay, let's jump into the video. A seemingly innocuous notice published last month by Marco Rubio, Secretary, U.S. Department of State, has wide-ranging implications for immigrants in the U.S. or those aspiring to work or study in America. It reclassifies immigration and border-related regulations, stating that these are foreign affairs functions. In other words, immigration policies can now bypass the public notice and comment rulemaking process, which is required under the Administrative Procedure Act. The foreign affairs function exception exempts certain activities from APA requirements like notice and comment rulemaking. By expanding this definition, the notification seeks to remove a vast array of government actions from APA procedural safeguards. Under the APA, the public can give comments on a draft regulation during a 30 to 60-day open window period. The concerned agency must consider these comments and respond in a final version of the policy. In Trump's early regime, various policy changes have been overturned by courts as they had violated the APA. For instance, Stanford University, Cornell University, and various chambers of commerce had successfully challenged policies that had proposed to hike wages of H-1B workers by as much as 40-100%, narrow eligibility norms for H-1B visas, and reduce the visa tenure to 1 year in case of placement at client sites. Judge Jeffrey S. White of the U.S. District Court, Northern District of California, in his order dated December 1st, 2020, had held that the Trump administration had failed to show there was good cause to dispense with the rational and thoughtful discourse that is provided by the APA's notice and comment requirements. No requirement for notice to comment. Greg Siskind, co-founder of Siskind Susser, an immigration law firm, told TOI, "For years, we have seen U.S. Citizenship and Immigration Services impose policies via memo, and lawsuits have successfully challenged this. So, I am guessing the Trump administration want protection to make rules without any of the public-facing protections required by the APA. I think avoiding APA is exactly what they're trying to do," added Stephen A. Brown, partner at the immigration law firm of Reddy Newman Brown. Florida-based Ashwin Sharma said, "Rubio's memo is a procedural Trojan horse. It quietly unlocks the gates, granting Trump 2.0 unchecked freedom to reshape immigration law at will. While this sweeping power grab will inevitably face fierce legal pushback, courts have repeatedly rejected such overreaches. The immediate impact could still be devastating, especially for Indian nationals. As a practical matter, this foreign affairs determination attempts to create a regulatory fast track for the Trump administration's immigration agenda. Note that courts have historically been skeptical of broad applications of the foreign affairs exception, particularly in immigration contexts where the connection to diplomatic functions is tenuous. While agencies such as Department of State, Department of Homeland Security, USCIS, Department of Labor, and others could now claim authority to revamp the H-1B program or eliminate H-4 EAD work permit given eligible spouses of H-1B workers without public input. This approach contradicts decades of administrative law precedent that has required agencies to show specific, definite undesirable international consequences before invoking this exception. The ramifications extend beyond procedure. This determination signals an intent to implement immigration changes rapidly and with minimal judicial oversight, said Rajiv S. Khanna, managing attorney at Immigration.com. What could be foreseen? Sharma foresees renewed and relentless attacks on H-1Bs, tightened eligibility standards, skyrocketing denials, and crushing requests for evidence during application processing, as also elimination of H-4 work permits, stripping thousands of Indian families, especially highly educated spouses, of livelihoods. We need to brace for crippling new restrictions on extended 2-year tenure for optional practical training currently available to international students from the science, technology, engineering, mathematics field, vilifying Indian students as backdoor immigrants, despite their essential contributions to U.S. innovation. Khanna said, "Be mindful that this foreign affairs determination creates an unprecedented situation. Previously, the IT industry, universities, and advocacy groups had 30 to 60 days to analyze proposed immigration rules, identify problematic provisions, and submit substantive comments that agencies were legally obligated to address. Now, the first time these stakeholders might learn about a new H-1B or F-1 policy governing international students, when it is published as a final rule and already in effect. For Indian IT companies with significant U.S. operations and the nearly 75% of H-1B visa holders who are Indian nationals, this represents a dramatic reduction in procedural protections and predictability. By framing immigration as part of broader foreign policy, it allows the Secretary of State to drastically reduce procedural safeguards and potential challenges for visa applicants seeking redress or contesting decisions. It may also make it easier for the government to adjust policies in response to shifting international relations or diplomatic concerns, impacting the stability and predictability of employment-based visa programs, said Kripa Upadhyay, immigration attorney at Buckleter. According to Khanna, the government's procedural maneuver, paired with recent measures targeting immigration attorneys, suggests a comprehensive strategy to implement restrictive immigration policies with minimal resistance. I foresee a two-pronged approach. First, using the foreign affairs exception to rapidly publish final rules without notice and comment. Second, discouraging legal challenges through sanctions against attorneys and firms who represent immigrants. For the Indian diaspora, which has traditionally relied on both administrative advocacy and litigation to protect its interests, this combination is particularly concerning. Companies and individuals should prepare for potential disruptions by developing contingency plans and exploring alternative visa categories or markets. Because the foreign affairs function can be subject to diplomatic and geopolitical changes, applicants may experience delays in the visa process as U.S. consulates adjust to new policies or international relations dynamics. This could lead to longer waiting periods for interviews or decisions, as consular officers may need to coordinate with other U.S. government agencies to ensure that visa approvals align with broader foreign policy goals. Added Upadhyay, can the new immigration policies that are introduced without following APA be challenged? A hope remains that new immigration policies that are thrust upon unsuspecting stakeholders, virtually overnight, could still be successfully litigated. Cyrus D. Mehta, New York-based founder of an immigration law firm, told TOI, "I foresee that the administration will issue more regulations without getting public input. Obtaining such input from the public is a win-win for all, as the administration can issue rules that would be acceptable and less likely to be challenged in court later as not being consistent with the statutory provision." After a Supreme Court decision last June 2024, Loper Bright v. Raimondo, courts are no longer required to give deference to a government agency's interpretation of the statutory provision enacted by Congress. Therefore, there is now a greater chance that a new rule could be successfully challenged in court as the government's interpretation of the rule can be more easily set aside. Can this notice issued by the Department of State itself be challenged? The courts remain the ultimate arbiter of the limits of executive authority, and this determination pushes those boundaries to their extreme. In my assessment, there are strong grounds to challenge this notification based on administrative law precedent that has consistently rejected expansive interpretations of APA exceptions, states Khanna. According to Mehta, it may be difficult to challenge the DOS notification itself as it is just a general pronouncement. However, when the administration next issues a rule and claims a foreign affairs function exception in the Administrative Procedure Act, the invocation of the exception can certainly be challenged in court on grounds that the rule has no relation to the foreign affairs of the U.S. May 2025 Immigration Alert. 10 critical changes you must know now. Big changes are on the horizon for U.S. immigration, and they're not optional. Whether you're applying for a green card, renewing a visa, or planning a future move to the United States, the new policies taking effect in May 2025 could significantly alter your path. from stricter documentation to registration requirements and delays due to visa retrogression. These updates demand close attention. Every step now matters more than ever. Here are the 10 most important immigration changes you need to know. Clearly explained so you can prepare ahead. 1. New filing rules for family-based green cards. Starting May 2025, USCIS will require applicants in family-based green card categories to follow the dates for filing chart rather than the final action dates when submitting Form I-485, Adjustment of Status. This change allows eligible individuals to apply earlier, particularly benefiting the F2A category, which includes spouses and unmarried children of lawful permanent residents. However, tracking the correct visa bulletin chart each month is now essential to avoid missed opportunities. 2. Mandatory registration for long-term visitors. A federal rule effective April 11, 2025, requires all non-U.S. citizens aged 14 and older staying in the U.S. for more than 30 days to register with USCIS using Form G3205R. This includes providing biometric data, such as fingerprints, if not already collected. Parents must register children under 14, and once a child turns 14, they must re-register within 30 days. The new policy is part of a broader push for real-time immigration tracking and national security enhancement. 3. Final action dates required for employment-based applications. A critical shift impacts EB-1, EB-2, and EB. Beginning May 2025, only final action dates will determine eligibility for adjustment of status, eliminating the prior use of the dates for filing chart in employment-based categories. This means no more early submissions. Your priority date must be current under the final action chart to proceed. 4. Stricter vetting for non-immigrant visas. Applying for a tourist B1/B2, student F1, or other temporary visa. You'll now need to provide 5 years of social media history and 2 years of international travel records. Additionally, applicants must prove strong home country ties, such as a stable job, family responsibilities, or property ownership. Even minor inconsistencies can trigger delays or denials, so meticulous preparation is key. 5. EB-5 visa retrogression for China and India. Investors from China and India under the EB-5 program face significant setbacks. Due to overwhelming demand, unreserved EB-5 visas for these countries are retrogressing, with projected wait times exceeding 2 years. To mitigate delays, consider investing in rural or targeted employment areas, which may still have available visa numbers. 6. EB-4 category temporarily closed until October. The EB-4 category, covering religious workers and other special immigrants, is closed until October 1st, 2025, as the FI 2025 cap has been reached. Applicants in this category must either wait or explore alternative family or employment-based options if eligible. 7. Stronger address change rules. USCIS is reinforcing a previously under-enforced rule. You must report any address change within 10 days using Form AR-11. This is crucial for receiving notices about interviews, requests for evidence, or approvals. Missing this step could result in missed deadlines or even denial of your case. 8. Barcode matching now mandatory. Starting April 2025, the barcode on your DS-160 or DS-264 must exactly match the one used when scheduling your visa interview. A mismatch, however small, could result in automatic cancellation of your appointment. Double-check all documentation before final submission. 9. Document upload deadline. 72 hours before interview. Applicants must now upload all supporting documents at least 72 hours before their visa interview. This includes financial statements, affidavits of support, and proof of property. Submissions cannot be altered after upload, and missing the deadline could lead to interview rescheduling or delays. 10. Delays in certain green card categories. Be prepared for extended processing times in 2025, especially for asylum-based and refugee-based green card applications. These cases are now subject to enhanced national security screenings involving multiple agencies. Applicants flagged for risk may experience months-long delays. Prompt responses to requests for evidence are critical to keep cases on track. That is all for today in this video. What are your thoughts on this? please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take